Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists nurse practitioners with employment contract and independent contractor agreement issues. Today I'm going to talk about nurse practitioner telehealth contract terms. So what are some considerations if you're an NP that's looking into getting into telehealth, and some things to avoid? First, you need to know what the state law is regarding supervision or collaboration. Obviously, many states require some kind of collaboration agreement between you and a physician. And so just because you are doing telehealth doesn't mean that isn't necessary. So you need to identify whatever the Board of Nursing rules are in your state regarding collaboration or supervision, and you're going to have to adhere to them even if you're doing telehealth. So that's the first consideration. Second, are you licensed where you are practicing? Meaning, maybe you are licensed in Florida, but the patients are across the country. You are not licensed to practice as a nurse practitioner in other states where the patients are. This seems like a relatively straightforward concept, but from the number of people I speak to that don't understand it, I think it's important to know you got to be licensed in the states where you're providing care to the patients. And so you need to make certain that you're not in some kind of a telehealth contract where they're just queuing up everybody from a bunch of different states and expecting you to provide care. So that would be practicing somewhere where you are simply not licensed. Next would be documentation. So there absolutely should be some kind of online EMR or system in place from the company that you're working at where you can document appropriately and have access to those documents. So you need to make certain that there is something in place that's going to meet the requirements of the documentation standards for the Board of Nursing in your state. Next, non-competes. So this is a big issue that really hasn't worked its way through the court system yet, or at least not, I think, at a mature stage of the process. During COVID, this certainly was kind of a telehealth boom, and it's still continued to be, popular. And I assume as time goes on, it'll continue to gain in popularity. But the non-competes with telehealth companies is, I would consider, fairly wonky at this point. I don't think someone's come up with some kind of grand solution for how to handle it. But some red flag areas you want to avoid. Well, one, you don't want super broad language that says, you can't practice as a nurse practitioner within, let's say, 10 miles of any patient that you provided care to. And think of it this way. You have no control over where these patients generally live. And so if you're working for a large telehealth company that provides care throughout the state, it could knock out the majority of the state. Now, one, probably unenforceable, but it is pretty common to have some language in there that states you can't provide telehealth services to anyone in the entire state, not just from where the patient's located, but from where you are located as well. So you have to narrow the scope. And then you also want to make certain that the scope is only telehealth services. So if you're an NP working a standard, outpatient clinic job, you don't want the telehealth, restrictions and the non-compete to make your ability to practice in an outpatient setting impossible. So the scope of whatever non-compete you sign should say you can't provide telehealth services as a nurse practitioner, which would then allow you to do, you would at least theoretically should be able to do any kind of outpatient stuff where you are located or close to wherever you're located. There are also companies that provide telehealth services in multiple states, and usually if they bring in a provider, they would like them to get licensed in all those multiple states as well. So you don't want the language in the non-compete to completely knock you out of, an entire region of the country. So before you sign any kind of telehealth contract, either as an employee or an independent contractor, you need to be very careful about what is the language in the non-compete to make certain that it's not going to stop you from practicing either with another telehealth company or on your own, giving in-person care. Response expectations, I think that's important as well. Clearly defining the scope of what you're going to provide. So if you're providing care to someone, there's usually some kind of follow-up. So you need to know, what are your scheduling options? How, when do you have to be made available? What are your charting duties? How do you handle patient follow-ups? It's many times, if you're providing care to somebody, there's at least some kind of expectation that there's going to be a follow-up. And so you need to know clearly what are the expectations of the employer regarding your care and follow-up. And then also, what is the compensation for doing that? Are you only getting paid for the time where you're providing patient care, and then you're just expected to provide another level of uncompensated care after that? Well, that would depend upon the compensation structure. Are you paid hourly? Well, then that's an issue. Are you paid some kind of daily rate? Are you paid per patient? Are you just given a base salary? The compensation matters when it comes to follow-up and whether you deserve to be compensated or not. So that's one thing to think about. That's about it for telehealth contracts for a nurse practitioner. Obviously, there's dozens of more things we could go over, but I don't like doing videos much longer than this one. So if you have any questions about your employment contract or independent contractor agreement, feel free to contact my law firm at the information listed below in the description. And I appreciate you watching the video. All right, thanks. Take care.